The President of the Republic of Kenya began today, joined on the program tonight by Senior Counsel Charles Kanjama, and Bobby Mkangi is also joining us from Mombasa, constitutional expert, and was a member of the committee of experts that gave us this constitution, which we are exercising here today. Charles, let me begin with you. What do you make of the process today? Let's understand this being something that we're doing for the first time, impeaching a deputy president. We've impeached governors before. But, you know, just your initial thoughts on the process that unfolded today.
The courts have already had occasion when we've had impeachment of governors in county assemblies in Embu, Meru and elsewhere to reflect on what should be the constitutional process. It doesn't change just because it is a president or a deputy president. The only difference is that instead of the proceedings beginning in the county assembly, they begin in the National Assembly. And the courts have said there are 3 steps in the process of impeachment and the trial. The first is the motion. In this case, the motion requires 1/3 of MPs. The second is the consideration of the motion in the National Assembly. And this requires 2/3 of the members of the National Assembly. And the third stage is the impeachment trial. Many Kenyans mistake impeachment and removal.
Okay.
The impeachment is the process that leads to you being put on trial in the Senate. So the moment the National Assembly votes with 2/3 majority resolution to put you on trial, you are impeached, but you are not removed from office. So impeachment is a process by which you are put on trial. And the trial takes place in the Senate. It's the third step. The courts have said that in the first 2 steps, you need to have a fair administrative action. So you need to have a chance to present your side of the case before the National Assembly or the County Assembly, as the case may be. Before the Senate, you have a right to fair hearing, which is a higher level of safeguard, where you are enabled to cross-examine witnesses, to present your own witnesses in support of your case. So those are the 3 steps that we may see if the process goes on as the movers of the motion hope to completion in the Senate. At any stage, any person aggrieved with the process can approach the court. The courts have previously stopped impeachment processes at the stage of the motion, at the stage of the resolution before the trial in the Senate, and on some occasions after the trial in the Senate. As we know right now, Governor Kawira of Meru has been impeached and removed from office by the Senate, but she's still in office, courtesy of the High Court issuing an order stopping that action from taking place until they review the charges that have been lodged against her and the process that took place in the Senate.
Okay, and you've talked about the courts. I'll go to Bobby in a moment, but you've really explained the process. What happens at the Senate with the trial? How many senators would need to vote for the removal of a deputy president?
So in the Senate, you need 2/3 of all senators
as well. Okay.
To vote in support of the motion to remove. And the Constitution gives an option. One option is that the whole Senate can sit as a committee to consider the charges against someone who's been impeached. And the second is the Senate can set up a committee of 11 members who are given 10 days to consider the charges against the deputy president in this case, or whichever state officer comes before them.
Okay, and that 11-member committee would consider those, but it would have to be brought to the whole House of the Senate, right?
When there is use of an 11-member committee, or indeed any other committee, the committee has the power to quash the charges before they are considered by the whole House.
Okay.
But if the committee approves the charges after the hearing, then the whole Senate votes on the impeachment motion, either to adopt it or to reject it.
Okay. And the moment where the person being impeached gets the moment to have a fair hearing That's at the Senate or the National Assembly?
That is at the Senate. The fair hearing is almost like a court case.
Okay.
That is at the Senate. The fair administrative action is at the National Assembly. And that one is just that you are given an opportunity to respond to the charges by maybe giving your response in writing or having a few minutes or an hour or so to present your position.
Okay. So let's talk about what happens in the courts now. Bobby Mkangi joining us from Mombasa. Like we've heard, you know, the stages of what happens at the National Assembly and at the Senate. But we've seen courts intervening fairly often. There is Bobby Mkangi. We've seen the courts intervening fairly in several instances of an impeachment motion. What would be the options if this impeachment goes through for the deputy president at the courts?
Sorry, I didn't get you right at the end.
Okay, I'm talking about the court process.
Come again, please.
Can you hear me okay, Bobby?
Now I can hear you.
Okay, great. So we were just getting an understanding of the process at the National Assembly and at the Senate with the hearing. The impeachment happened and the removal from office by the Senate. There are still options at the courts, right? Explain to us that process. Yes. Take us through that.
Well, I think as Senior Counsel Kanjama has explained, the option of, and especially ensuring that there was a procedural propriety, that the right constitutional process, the right parliamentary procedures, examining aspects of, if there are thresholds that have been given in the Constitution, if those were followed to the letter. And we've already seen in this case that a number of Kenyans have already approached courts asking the courts to intervene and even initially to stop the process before it starts. And there are, I think, dates that have already been given for the substantive hearing around the prayers that those who went to court did present before court. So that avenue and that cause of redress for the subject who is being taken through this process, and in this case, Deputy President Rigathi Gachagua, open to him constitutionally. And it's mainly because in as much as this is a political process which is being prosecuted within pretty much a political theater of operation, the Constitution does provide a very specific process, formalities that have to be followed. And if those are not followed, and as Senior Counsel Kanjama mentioned, and as we have seen in previous impeachment processes involving governors, the pronouncement of the Legislative House, and for this matter the Senate, may not be the final say in this cause, because that avenue of the Deputy President going to court, already some Kenyans have gone to court, but even thereafter presenting fresh petitions and appeals against the decision of the Senate. And primarily, as I said, asking the court to examine the veracity of the process, whether it's the substance of the grounds and whether those were adequately and optimally canvassed, but more so the procedural aspects of the entire asking of the Constitution, whether those were followed to how Kenyans pronounced and dictated in the Constitution, so that the courts can examine those and then make a final determination as to whether the constitutional guarantees have been followed or not.
And Bobby, this could go all the way to the Supreme Court, right? Depending on how it goes, you know, the High Court, Court of Appeal, this could go all the way.
I think that is the anticipation beyond, if, depending on what the Senate eventually decides, how it pronounces itself. And I think, as we've seen with also other processes, I think these are contests that the different players and the different institutions. And when you look at the gravity of the issue, you know, it's a constitutional, you know, an issue of very primary constitutional concern. Already we are seeing the contestation, the level of contest, and whether it's from Parliament itself and on the other side, the Deputy President, we can see the appetite to take this contest to the final juncture of determination. So yes, as you say, I think the foresight to this, and judging from the history of similar processes, is that most probably it is the Supreme Court that will have or may have the final say of this process.
Okay. Charles, let's talk about the grounds. Kibwezi MP, who's the mover of the motion, Mwengi Mutuse, laid out 11 grounds. So take us through, you know, based on the Constitution, what are the grounds for impeaching a deputy president? And from what you've been able to see that was presented, where that falls based on the Constitution? But also, would he need to be, you know, found guilty of all 11? 1, 3, 7? Is there a threshold?
Okay, so the grounds for removal of a deputy president are the exact same grounds for removal of a president. They are found in Article 145 of the Constitution, which refers to removal of a president by impeachment, and Article 150, referring to deputy president, refers to Article 145. And it mentions 3 grounds which you need to apply or to consider for removal of a president or deputy president. You don't need to comply with all those 3 grounds. A single charge that has been proven relating to any of those 3 grounds is sufficient to remove either a president or a deputy president. The first ground is gross violation of the Constitution or any other written law. Not a minor violation, but something that's considered serious. And the court has previously discussed what does it mean to be a gross violation. Something that has serious effect on the Constitution, on human rights, effects on public interest, and is a clear violation of the Constitution that can be directly attributed to that person, and not indirectly but directly. That's a gross violation. That's the first ground. The second ground is more suited to the office of the president, but it also applies to the office of the deputy president. You see, the Constitution says that you cannot lodge a criminal or civil case against the president while they are in office. So because you can't lodge a criminal or civil case against the president, if you feel that the president has committed a criminal offense, you are meant to first commence impeachment proceedings on the ground that there is reasonable suspicion. There is reasonable ground to believe that the president has committed a crime under local or international law. So that if the president is then impeached, you then proceed with those charges in the normal courts because they no longer have the immunity that they had before. Somehow that same ground applies to the deputy president. But in the case of the deputy president, there is nothing that stops you from even lodging a criminal case against the deputy president while they are in office. Nonetheless, that is the second ground for impeachment, a reasonable belief that they have committed a crime under civil criminal, local, or international law. And the courts have said that the test for this is not beyond reasonable doubt. That is the standard.
What does that mean?
The standard of proof when somebody is charged in court with a crime is beyond reasonable doubt, that there is no reasonable doubt that could exonerate the person from the offense that they have been charged with. That is a criminal standard of proof, of evidence you need to bring. The courts have said that in an impeachment case, the standard of proof is above the civil standard. The civil standard of proof is on a balance of probabilities, that it is more likely than not that the offense was committed. That's the civil standard. The criminal standard is the one I've talked about, beyond reasonable doubt. There is no reasonable doubt that you could entertain that the offense was not committed. So the courts have said that for impeachment, it's an intermediate standard. It's in the middle. It's a standard that is above the civil standard, but below the criminal standard. So you don't have to prove the actual commission of an offense as if it's a criminal trial, but you need to show strong evidence that a criminal offense was likely committed.
Okay.
That is the second ground. Then the third ground is gross misconduct. And again, the courts have defined or explained what is gross misconduct. They've not said, they've said it's not just any misconduct, anything that is considered harmful to the society or the state. It is something that causes serious harm. So those are the three grounds. Either you have violated the Constitution or written law. Second, you may have committed a crime under local or international law. And thirdly, you've engaged in gross misconduct. So the impeachment motion against Gachagua has attempted to bring alleged offenses against each of those three standards that you're meant to meet in order to succeed on impeachment.
And with those, I want to still stay on the grounds of impeachment. And Bobby, let's go to you for a moment, because you were in the committee of experts drafting this constitution. Help us understand the difference between having a deputy president, under the Constitution of Kenya 2010, as well as, having a vice president before. The understanding for some is that this was an indivisible ticket, right? You vote for one. And some of the proponents or the supporters of the deputy president are saying you cannot impeach one without impeaching the other. What's your understanding of the law? Is this one indivisible ticket? Because when you go to the ballot, you vote for two individuals, it's one line and you're voting for them together. You don't, get to pick and choose. And so some say, well, impeachment should be, not of one or the other. But the Constitution does state clearly the difference. But what are your thoughts? Is this an indivisible ticket? Do you impeach one without the other? Do you impeach both?
Well, it's an indivisible ticket at the point of electing the two individuals. And maybe I should go to the reason why. When you study the history of the constitution-making process in Kenya, right from when the Yash Palgai team, the Constitution of Kenya Review Commission, started this journey way back in 2000. And they started by going and seeking the views of Kenyans. And they visited the 210 constituencies as they were then. You will discover that Kenyans actually did recommend that the president be elected together with the vice president, as the position was known back then. So this was a proposal that came from Kenyans way back at that time, and their feeling was that the running mate system was helpful in ensuring that the presidency comes with a formulation that helps to, in a way, divide and ensure a division of the different aspects that attend to the position and also the power bracket that the position does portend. It allows, and as has been seen in other jurisdictions, one, even in the element of separation of powers, but also in checking and balancing that very strong and powerful office, but also helps in dealing with other aspects of diversity. When you look at a country like the USA, the Biden and Kamala ticket helped to infuse the gender aspect into that office. When you go to Nigeria, there is a demarcation between the North and the South, where it plays out the Islamic and the Christian aspects of a ticket are guaranteed through that. And so when you go back to that history of how Kenyans propose that, you see the same appetite, you see the same reasons visiting to that. And so at the end, in 2010, in as much as eventually through the process, Kenyans agreed to a presidential system where we see that the traditional formulation is as is right now, that was not the sole reason for Kenyans formulating this, but it goes back to even when in the previous documents you look at the Bomas draft, it was still the same formulation, that the president will be voted in with a running mate, and therefore a deputy president who will automatically, the president or the candidate, the presidential candidate nominates, but the people elect the two, a president and a deputy president who becomes a principal assistant, but also we may say a standby president, because if there's a vacancy or a vacancy occurs in the office of the president, then Kenyans do not have or did not want to go back to the ballot because of the expense, but also the logistical considerations, because this is a national election where the entire country must go into an election or electioneering mood. And so in terms of the ticket, yes, it's a joint ticket at the point of electing the presidency. But Kenyans also decided that in as much as they do come in as twins, they are not Siamese twins. And that's why in terms of in the performance and evaluation of their performance, and if it comes to the point where any of them must be held accountable in the way they are executing their constitutional mandate, then that accountability must be looked at individually. And that is why Kenyans provided that the president can be impeached through Article 145, as Senior Counsel has explained, but the deputy president can also be visited with the same through Article 150. So joint ticket coming in, but in service in as much as they serve together, but in holding them accountable to their performance, they are held accountable individually. And that is the formulation that we have today.
Okay, yeah, interesting analogy. They're twins, but not Siamese twins, so they're not, joined at the hip, as it were. So you can impeach one and not the other, right? The
yes.
Constitution, like he said, provides for that.
And the Constitution actually contemplates what happens if you successfully impeach one and not the other. So, for example, if you impeach the president and he leaves office, the deputy president succeeds him as president and then can appoint a new deputy. And if you impeach the deputy and you leave the president within 14 days after the deputy has been removed from office, then nominates a new deputy who has to be approved by the National Assembly within 60 days, and then takes office. So the Constitution actually contemplates that even though they came in, as my colleague has said, as twins, they are not Siamese twins, and one of them can drop off and the other remains. And this is actually a practice in many other countries that have a similar presidential system with one ticket for president and running mate.
Okay, and you know, the person that a president would select in the event of impeachment and removal of a deputy president, any stipulations in the law about where they can come from? Can they be elected? Must they be technocrats? Must they be...
The law has no stipulation,
so
apart from the fact that they need to be people who would qualify to be elected as president or deputy president, which means, for example, you are a Kenyan citizen, you've complied with Chapter 6 of the Constitution, and so on. Okay, okay. But it can be from anywhere. All right, guys, we've got so many more questions, including those from you. Watching us tonight, the hashtag is The Explainer at Citizen TV Kenya, at Yvonne Okwara. If you've got any questions, please do send them through. We're still here with Senior Counsel Charles Kanjama and Bobby Mkangi. We're talking about the impeachment process and in what ways perhaps this differs from before. We have seen before it was called a motion of no confidence, right? For what we called then a vice president versus now impeachment of a deputy president. So we'll come back and talk about some of those comparisons, including any questions you've got of the process and what we are seeing now and in what ways, you know, it exercises the muscle of the Constitution of Kenya 2010. We're back in a moment.